On PM Express tonight, something that was broken here on the show last night around 10 p.m. The RTI bill has finally been passed. The big question is, what next? It sounds straightforward, but it is a big question, which is still being debated even after this historic bill was finally passed in Parliament last night. Parliament passed the RTI bill into law on Tuesday, just after more than a decade. In fact, an upwards of close to 20 years has been in Parliament, we know now. Now, the passage of the bill gives substance to Article 21(1) of the Constitution, which states, and I quote here, you see, all persons shall have the right information subject to such qualifications and laws as are necessary for a democratic society. This is enshrined in our Constitution. This particular clause gives a lot of life to this. There are reservations tonight, however, about the part of the law that was passed last night. The Media Coalition on RTI have some reservations with some of the clauses of the law it deems potential barriers to accessing information. So what are these? They've touched on a few. The coalition also has issues with these clauses, and they will explain shortly. For example, clause 13 provides that the deliberative process of every institution should be protected. They have a substantive disagreement with that particular clause. The coalition says this clause gives protection to public institutions under the guise of shielding deliberative process. That's the position that they're taking on it, and that the blanket protection could be misconstrued and used to deny those who apply for information under this particular law. Now, again, the coalition says that the House did not consider some final amendments it proposed, which goes to the heart of this particular bill. We'll examine some of the concerns shortly, including the time frame for putting in place the necessary structures for effective implementation of this particular law has also come up for some scrutiny. Now, the RTI bill was first, and this is really important. We are tracking how this has traveled over the last 20 years. And in the euphoria, we seem to forget how far we've come. 1999, and yesterday we got indication on this from the longest serving member of Parliament, Abdallah Banda. 1999, this bill was drafted, he says. In 2010, it was presented to Parliament for consideration. In 2011, government signed the Open Government Partnership Initiative with commitment to pass this particular act. We know that now. In November 2013, the bill was formally laid before Parliament again. Now, in 2015, motion was moved for the second reading of the bill in Parliament. In 2016, the bill was withdrawn and then was replaced with a new one, which was immediately laid as well. Now, following the dissolution of the state parliament, we all know what happened. The bill had to be relayed by the new government before work commences But this is a big question. What next? But tonight, there is a fundamental disagreement that the minority guys have raised, which is something that happened towards the tail end of the passage, which changed the shepherding institution from the Attorney General to the Information Ministry, and that has sparked, I guess, the latest controversy. We'll be interrogating why that happened, and then with the guests who understand this. And for us here, we're delighted that we are joined in the studio today by Abdallah Banda, who is the chairperson of the committee that had worked on this matter, the Constitutional, Legal and Parliamentary Affairs Committee. He joins us in the studio. Also, Samuel Obeng, who is Executive Director of the Parliamentary Network Africa. They've all been part of the coalition working on this, and they will help us try and appreciate what this law really says and in essence, get to the bottom of it and explain some of the thorny issues that we still are hearing from all sides in this. Stay with us. When we return, we'll get into the what next factor. And some say maybe this deserves a champagne. We'll see if we can pop a champagne as we have this all-important conversation. At least after 20 years, we need to pat ourselves on the back. But some already predicting, give us 2 years and we're back to the point where we are frustrated that no institution is willing to implement this law. How do we avoid that from happening, following other laws that we so wanted to pass? When it's passed, nobody wants to implement. Stay with us here on PM Express. My guests are seated to the radio on this all-important conversation. And I want to say first, Abdallah Banda, congratulations.
Thank you very much.
Yeah, because I remember you were here just this year when with Dr. Kojo Asante, and I said, when it's passed, you deserve some champagne. Have you popped the champagne yet?
No, we haven't done anything of the sort because we think that it is our responsibility as parliamentarians that any bills presented to us as much as possible must be passed into laws. And we see the passage of the right to, the right to information law as one of the core responsibilities of members of parliament. So I will say that if there is any praise or commendation that has to be given, I think that it has to be given to the president, because the political will of the president determines whether a policy must be executed or not. And we will all attest to the fact that the president, right from the onset, did make his intention clear that the right to information bill was one of the bills that had to be passed into a law. And that, fortunately, yesterday saw the light of day. If there is any commendation that has to be given, that commendation has to go to the leadership of parliament, especially the majority leader, because it is the majority leader or the leadership in parliament that determines the business of the house. And at all material times, they had made their intention clear that the right to information bill must be treated with all the agency it deserves. And that is the outcome that we witnessed yesterday. If there is any commendation or praise that has to be given, I think that praise has to be given to the members of the committee,
Your committee
on Constitutional, Legal and Parliamentary Affairs, because it is their contribution and the assistance that carried the committee on our journey right from the onset to the destination that we got to yesterday. And the Speaker of Parliament. So it's like everybody wanted the right to information law passed, or right to information bill passed into a law, and that is what we saw yesterday. So before the passage of the bill, or before the passage of the law, leadership insisted. Leadership were given assurance that the right information will be passed into a law. Many were those who were doubting Thomas's.
I doubted it.
Apprehensive.
Yeah, but you knew why, because we've had so many promises, broken promises.
The passage of the law was long overdue. Yeah. And this is a bill that has suffered a lot of, somebody would say, parliamentary abortions.
In nearly, actually, yesterday, for what we understand, it suffered an abortion because there were people who were saying the amendments that had to come, that had been taking a wait for it to happen. Let me bring in Samuel. Samuel, you also deserve a big congratulations, because I know you and
in fact, I even forgot the coalition. Coalition also did very well. And other civil society organizations.
Your group deserve great commendation as well for fighting on behalf of everybody else. I know it's been tireless weeks and nights of, meeting with this fine gentleman here, trying to convince him to accept some of the proposals and recommendations that you set yourself. Yesterday, where were you when you heard the news that had been passed?
I was actually watching the live streaming together with some of my team members on Facebook. So we're watching it live while some of the other team members were in the...
So you had a watch party?
Well, it wasn't entirely a watch party, and I think it is important to mention that, just like the Honorable Chairman of the committee has indicated, I am particularly excited to be on the set with one of the most hardworking committee chairpersons we have in Parliament, and this is not a joke at all, because I know that we've worked with his committee on a couple of draft legislation, Office of Special Prosecutor, Witness Protection, Right to Information, and we know the kind of effort and work that he and his committee members put in getting this done. While we're watching yesterday, we were very hopeful that the bill will pass, but we're also hopeful that some of the final amendments that we had proposed were also going. So at the end, when it passed,
were the final amendments factored in before it was
No,
passed?
they weren't.
Okay, so we'll go into that. We'll go into the substance of that.
So
but at least fundamentally, you are happy.
We're excited.
But you were hoping that it will be passed in a better shape than it was passed.
Much better.
With your proposed amendments that you proposing towards the end. Okay, so that's where we are. It's good to congratulate them, but let's go into the substance, because there are a few things that we still need to address going forward. This is not, it's been passed, but it's not tidy yet. There's a lot of things I've heard. I think you said that we need to tidy it up a bit before it goes to the president. One of the things that had come up very strongly was this. We heard from the minority leader, Haruna Idrisu, which I understand was introduced into this either yesterday or very late in the day. Listen to Haruna Idrisu, minority leader.
Legislation which can strengthen the hand of government and parliament and other allied institutions entrusted with the mandate to combat corruption. What corruption hates is darkness. A right to information bill shines the sun. So right to information belongs to what we, in governance on corruption, a shine legislation. I believe that the government have already lost it. Lost it because the shepherding minister has been reduced to the Ministry of Information. Right to information is not about propaganda or government information or government misinformation. It's about the right of access to information to aid in exposing what decisions that the executive, parliament, and others may take. So in my view, to substitute the Attorney General for the Minister of Information itself waters down the policy credibility of a right to information. And Attorney General, because the mandate to combat corruption and to fight white-collar criminality, economic crime, and others rests on the shoulders of the Minister for Justice and learned Attorney General.
So that is the minority leader there. Honorable Chairman, so that's a consent. At what point was this introduced into the bill?
That introduction and the shifts of the ministry from the Ministry of Justice to the Ministry of Information was done after the consideration stage.
Okay. Was that yesterday?
That was not yesterday. No, in fact, when the ministry was changed, the ranking and I were not even in the country. But that issue had come up for discussions before we traveled.
Okay.
And because it was a major policy shift, Parliament needed to do a lot more consultation.
Okay.
So leadership in Parliament took it up with the Ministry of Justice and the Ministry of Information. And at the end of the day, they came to the consensus that once it is the Ministry of Information that is in the business of churning out government information to the public, then why don't we give the oversight responsibility to the Ministry of Information? And that is the consensus, to the best of my knowledge, that they came to. And finally, at the second consideration stage, that amendment was effected. That is changing the ministry, the oversight ministry, from the Ministry of Justice to the Ministry of Information.
Okay, so the primary reason, because I wanted to get to what the primary reason was, the thinking that information ministry, regardless of which government is in power, is the ministry that churns that information.
That's right.
And so if it's right information, then that ministry should be the oversight.
Yes, because once we have the Ministry for Information, and the right to information law is about information, why should we sidestep the information ministry and deliver the oversight responsibility to a different, to a different ministry? The concern being raised by my dear friend.
But this is an anti-corruption legislation.
Yes, I understand.
And so go to the Attorney General.
But you see, the point is that the concern being raised by my dear minority, that to me, that concern is not, it's unfounded.
Why?
In the sense that wherever there is a corruption matter arising, it is the responsibility of the Minister for Justice who must ensure the prosecution of that matter. And for that matter, wherever there is any criminal matter arising, it is the responsibility of the Minister for Justice who does that. And quite recently, and not long ago, we passed the Office of the Special Prosecutor Act. Corruption matters are to be investigated and dealt with by the Office of the Special Prosecutor, but not the Attorney General. So assuming that now there is a corruption matter arising within the Ministry of Information, which is now the oversight ministry over the right to information law, it is the Office of the Special Prosecutor that will come in to investigate and to prosecute, if any corruption matter that arises out of that ministry. So I don't see how the appointment or the designation or the empowering of the Ministry of Information as the oversight ministry over the right to information law will torpedo the process of having access to information.
Okay.
I don't see it.
Some of you agree?
Because
I want to bring someone into this
Okay,
shortly. So, some of you, do you agree with this change?
I mean, you realize that it's one of the things that it's not one of the things that we mentioned in our statement.
True,
at all.
you were.
And I must say that it's not one of the things that we have even considered as a coalition. My personal view is that the minority leaders' call is, to be best described as much ado about nothing.
Okay.
Because it is this simple. Now, this happened last week. Second consideration, we're all very excited. We thought that it was going to be our proposed amendments that were going to come up for second consideration. Then it was sprung on us that the shepherding ministry was going to change from Attorney General, who was the one who laid the bill, and the memorandum to the bill was written by the Attorney General to the Minister for Information. It was explained on the floor of Parliament that Cabinet had actually had a meeting on the matter, and Cabinet had decided that it be shifted for policy purposes from the Attorney General and Minister of Justice to the Ministry of Information. And that the majority leader together, and Honorable Abdallah was right, he was not in the chamber. Minority leader was not in the chamber. His ranking was not in the chamber, but majority leader was there. The Attorney General herself was there, and she indicated that yes, indeed, they've done that change, and so there is no problem. But you see, this was when the amendment was being done to the definition for minister, in the definition section of the bill, where minister was now being described. So wherever minister gets mentioned in the act, then it refers to the minister responsible for information, because the House was also minded that in different jurisdictions, there's been times when the Ministry of Information has been moved into communication. So this time around, they couched it as the minister responsible for information. Now, where does this come in? In the bill, there are times when the report of the commission must be presented to Parliament, just like we do in Parliament. In Parliament, strangers are not admitted, so the Right to Information Commissioner cannot come and present the report. Who stands in to represent the report for him or her in that instance? Minister responsible for information. So in things like that, in matters relating to appointment, supervisory, and I don't even want to use the word supervisory, because the Right to Information Commission is supposed to be an independent
Don't they
body.
answer to the ministry?
Well, so far as...
In terms of, say, regular reporting?
On
its
they are supposed to present their reports. Their reports and their finances are supposed to be audited. When all of these things are done, these things are supposed to come back to Parliament because of our oversight.
Does the minister have any say in the way they run?
To the best of my knowledge, not in a way that would affect the running of the ministry, and that is the running of the Right to Information Commission. And that is why I think that the minister there, so far as the bill is concerned, and so far as we are establishing an independent commission, is really for administrative,
Does the minister does the law give the minister any say in whether or not a information applied for is either exempt or cannot be given, and whatever reason there could be?
Per my reading of the law, no.
It doesn't. So that is very superficial in terms of, the shepherding role of the ministry. It's nothing substantive. It doesn't go to the substance of the law.
Yeah, I think that it doesn't go to the substance. And so for me, I don't think it's one of the weighty
the big things. Okay, you agree with that?
Yes, I agree, because you see, the structures that have been put in place to access information that do not give any role to the ministry responsible for information now, because you start from the public institution. And public institution, depending on where you are looking for the information, it can be situated anywhere. I have always used my constituency as a reference point. It can be situated within my constituency. And of course, within my constituency of Finso South, there is a public institution. If a person applies for the information, the application doesn't have to go to, or doesn't have to come to Accra to the minister for the minister to decide whether to grant it or not. It is the information officer within that public institution that decides. Okay. And from there, it goes to the head of the public institution. Okay? And the Right to Information Commission is an independent commission that has the oversight responsibility over all the public institutions here in Ghana. What the ministry comes in to do, as he rightly pointed out, is to ensure that reports that are generated right from the public institutions down to the Right to Information Commission are reported or are submitted to Parliament through the minister, because the public institution cannot on its own get up and submit a report to the Parliament. In like the same way, the Right to Information Commission doesn't have the locus to get up and present its reports
directly to Parliament.
Its report to Parliament. At all material times, and per the architecture of our laws, it is ministers who collect reports and present same to Parliament for parliamentary examination and perusal. So all that the ministry is coming in to do is to do that administrative work. Okay. That's all. Okay. So I don't see how.
So that settles the debate. However, you have very substantive concerns with the way it was passed without some of the last-minute amendments that you had introduced. One of the key ones I saw is this controversy about deliberative process. Right? Why is that important? What is that, by the way? Why is that a concern for you? Because that is under the exempt clauses, correct?
Well, deliberative, that's clause 13. Now, clause 13, yes, speaks about exemption.
Yeah.
I mean, it's part of those set of clauses that speaks to exemptions. And mind you, there were 7 proposed amendments for the second consideration stage. Clause 13 was one of the 7. Now, there were other ones. And I must say that in our discussions with the committee chairman, to for the want of a better word, lobby so that this change gets done, in our discussions with the minority leader, they all raised concerns about what they thought was not very, the fact that it wasn't very injurious, and they thought that other sides of the bill.
So explain to us, those listeners who don't know, when they say that particular exempt clause, what is the clause that you have a concern?
In essence, clause 13 says that if there is a deliberative process ongoing. So state institution, public organization, public institution deliberating on a particular subject matter. Information relating to that deliberation are exempt until the deliberation process is over. Now, it states it in that particular way. But, it's, in essence, it is implying that until the deliberative process is over. We wanted the law to be a bit clearer on at what point this deliberative process can be deemed to have been terminated. Because you see, we live in a country where police is investigating a particular matter. They say that it's deliberative process. Next 2 years you go and they are deliberating about it. I mean, you go the 4 years time and they are still deliberating. So how does that help us to be able to assess the kind of information that we are hoping to assess if that deliberative barrier can always be hidden behind to be able to block us? So we were saying that, look, just introduce another subclause which says that once the deliberative process is over, those information are not exempt, so that it can be very clear to the mind of whoever the RTI commissioner is. If we apply for information, they say it is exempt, we can go to the RTI commission and say that no, this is not exempt, we think that the process is over, for them to determine that as it stands now, it is implied. And we're trying to avoid implied systems in a law that is very new to our terrain. But I must say that we agree that it is not necessarily injurious to the entire function of the bill, because we have clause 17 also, which talks about the harms test, in respect of whether a matter goes to the heart of public interest rather than the reasons why they are being exempt. And we also think that the regulations and the airline that will come to operationalize the bill, we can use that.
So it's not fatal.
Yes.
But my question to that is, this particular clause has been in the draft form of the bill for a long time. Because each time I've read it over the last many years, I've seen this in there. So it begs the question, why didn't you push this earlier?
Well, you know, Evans, one of the things that the coalition did, Right to Information Coalition, Media Coalition on RTI and all of our partners, and we as Parliamentary Network Africa was leading this, is that we had representative research officers who sat in Parliament every single day. And that is how come the amendments tracker, which has been going around, is. So even now that Parliament is about cleaning the bill, we, the coalition, have like the current version of the bill, which shows all the conciliations and all of that.
But I saw a copy today. It was very confusing to read.
Yes, so we tried to make all the conciliations so that we can see what was changed. Now, it was at the end of the entire consideration stage that we constituted what we call a technical committee to relook at all of the changes that has been made, because by which time we had sent certain things to Parliament, and to see whether there are still certain areas that were injurious. Remember that in our previous recommendation to Parliament on what we call problematic clauses in the bill, 13 was still part of it. Okay. We realized that 13 had been slightly amended, but it hadn't been changed in a way that would solve the problem. So we came back to Parliament and says, we've been working with you all the while. Please, could you do something more about this? They met us and they said, well, we'll look at it. On the very 11th hour, they did it.
When I return from this quick break, I'll ask you to name for me very quickly your top other two concerns that you have with the way it's been passed, and I'll get the chairman's comments on whether these are, issues can be addressed going forward as Parliament itself waits to tidy it up before submitting it to the president to sign. Stay with us here on PMS. But the fundamental question, the biggest question for me is, we've seen in the past fantastic laws that we've passed after we have a lot of clamor, and then once it's passed, nobody really implements it. What is it that we're going to do so that this RTI bill, the longest bill in Parliament, 20 years, doesn't become another paper tiger? Stay with us here on PMS Press. Live on PMS, and I can see the conversation is still continuing, or even during the break. But Ms. Abdallah, before we went for the break, someone was talking about one of the main concerns that we're hoping that you would have dealt with, the deliberative process, which, by the way, has been in the draft in the bill for a while. They had attempted to try and get you to sort of make it a bit more clear. He says it's not fatal, and I'm sure you agree with him, but it has a challenge because of its ambiguity, and it may allow people to use it as an excuse to definitely deny people critical information.
I don't see the ambiguity inherent in the current clause 13, in the sense that one of the overriding considerations of the right to information law regime is proactive disclosure or maximum disclosure.
What does that mean exactly?
It means that at all material times, information must be given out without even the public asking for it.
Okay.
And every information that has to be disclosed must be measured against the public interest. That is the public interest override. The public interest must always be must always be the overriding consideration for a public, for an information officer who an application has been brought to him to determine whether to deliver or to grant the application or not. So back to clause 13. Clause 13, what is it saying? Clause 13, as he rightly pointed out, is that when a deliberative process is ongoing, opinion or advice proffered in the course of that deliberative process must not, information thereto must not be disclosed. And you see, there's a caveat. And the caveat here is that if the disclosure of the information is likely to undermine the deliberative process of the public institution,
okay,
it means that that information must not be disclosed. So what does that mean? What it therefore means is that even where opinion is being proffered, advice is being given in a deliberative process, if the disclosure is in the public interest, that information relating to that opinion must be disclosed.
Who makes that decision?
It is the information officer. But if the disclosure will undermine, that is what it is saying, if the disclosure will undermine that deliberative process, then of course, to the extent that it will imperil the deliberative process, any information relating thereto must not be disclosed. It therefore means that if the deliberative process is over, the information officer cannot purport to say that the deliberative process is over, and for that matter, I'm still entitled not to deliver the information.
But the information officer can still tell you it's not over, that we are still deliberating, and so I can't give you.
It's not over. It's a matter of fact, and it is subject to investigation. Because you cannot tell me that a deliberative process has been going on for 2 years and it's not over. The determination of whether the deliberative process is over or not cannot solely be taken by that public officer. Because if the time is not reasonable, for instance, a deliberative process that should take, let's say, a month or 2 months, it does not lie within, or it does not lie with the information officer to say that we are taking, let's say, a year or 2 years for that deliberative process to be over. At all material times, reasonableness will have to be taken into consideration.
You know, my biggest fear listening to you is that people have been given a lot of discretion in this matter. People, information officer, who else? The commission. There's a lot of discretion. You know, I know the Constitution says that if you have discretion, you must exercise it, you know, with fairness and, you know. But that worries me, because who is going to employ this information officer? And is this person even qualified to make that determination? Because the things you're talking about are very complex matters that somebody must make a decision on based on his own prejudices. We all do have. I mean, so what's a check here? What is a check? What is a check that the law provides?
You see, the check is that every information officer, every public institution must designate an information officer. And of course, if, for instance, tomorrow, a public institution has designated an information officer, that information officer within that public institution must be taken through some training.
Okay. Does the law provide that?
Yeah, of course. Yeah. Because if the person is not taken through some training, how
is the person able to make the decisions that the law requires him to make?
Get himself abreast with the provisions in the law? How does even the person in the first place determine the merit of an application that has been brought before him? So the person must first of all be taken through some kind of training, and the person must be educated and appraised of the content of the right to information law. Okay. For him to be, for him to be given the necessary skills and the necessary competence to deal with all applications that come before him.
Samuel, this has been my biggest question about the RTI. I was one of those, I guess, few journalists who was skeptical about whether we needed this law or not. And I've heard lawyers argue that we don't even need it because the Supreme Court had pronounced a judgment very recently that we know very famous, you know, giving life to the constitutional provision, which this bill law is supposed to also give life to. And in my line of work, I thrive very well on leaks, and it's worked for me. There's a question I have, which is that this law now actually can empower somebody to deny you information that you ordinarily, without the law, have had. So this is a practical example, and we can comment on this because I'm speaking purely as a journalist who does work. This information officer, whoever it is going to be, without this law, if I go to the ministry and I ask for information, they'll give me, because there's nothing that spells out what is and what is not, right? So sometimes I get information that is I shouldn't get, but I will get.
Or they will not give you.
Or they will not give me, but they'll give me. But now, this same source, because the thing is clearly exempt, can tell me, I'm sorry, now there's law is passed, this is done, so please go through processes that will now take time. And do you understand where people say that this law actually is freedom of disinformation rather than freedom of information, that it might not really help our cause going forward? Do you understand why that is? Because of all the discretion that people have been given in this matter.
Well, I do not understand. I disagree. And I do not understand and disagree because, I mean, for some of the places where you will get information, you are probably getting it because you are Evans Mensah. You are with a multimedia group.
True.
You are working with a media house that has the privilege so to get. Remember that right to information or access to information is not only for journalists, it is for the guy who is also doing his master's doctoral thesis and needs some form of information, who does not know how to go around and find the kind of information that you will find, but he needs that same kind of information. And so we must broaden this beyond just the media. It would be too self-seeking as media people if we just look at what we can find without the access to information and not the broader, society. One of the other things also, when he's speaking about the Supreme Court's rulings and the Constitution, what the Constitution and the Supreme Court's rulings does not do is that it does not tell you that now if you need information, go to an information officer, which must be present in all ministries, departments, and agencies. But the law does. It tells you there is an information officer. It does not tell you that within 14 days these people must provide the information to you. Now the law does. It tells you. It does not say that if within the 14 days and you apply for an information and you don't hear from them, it means that information you've been denied access. The law clarifies that. It does not say that there is an ombudsman through the Right to Information Commissioner who you can go to, but before even doing that, you must have to escalate the issue to the head of that particular institution because the information officer denied you. So it's more structured that you can follow and you can be.
Are you happy with the checks the law provides for in the case of abuse of discretion?
We think that to a very large extent, this law is very much related to international best practices. We know that the committee relied very heavily on the AU model law on rights to information. We relied very heavily on other access to information jurisdiction, because access to information regime is a very big topic globally. Yes. The Open Governance Partnership and all of the other things that are happening globally speaks about it. I must say that I am on a global open governance platform, and once the news was broken yesterday that Ghana's RTI has been passed, it was just like an election that has been successful, and everybody was congratulating Ghana left, right, center from all over the world. And so there are best practices. We as civil society provided some of these information to the committee. They also provided themselves with some of these information. They were very much willing to accept these information. They worked with it. And we think that the bill, we don't have a perfect law, yes, but there is no such thing as a perfect law. What we have now is not a very bad example of a right to information law. It could have been better, yes, but it's one that we can.
We've already mentioned the deliberative process, which is Supreme Court. Which is the next top concern of yours that you think subsequently, if you want to make this close to perfect, we need to address?
The next two that I would quickly want to, and I told you there were 7.
Sure.
Let me just highlight on 2. One is the matter relating to deferred access, 21.
Okay.
Now,
what does that clause say?
So that clause says that, assuming that the ministry, department, or the agency is already processing that information or is under law to disclose that information within 90 days. It's already supposed to disclose it anyways within 90 days. Let's say an annual report, they are supposed to disclose it at the end of March in every new year. So between October of the previous year right up to March, it is 90 days. You cannot go seeking that particular information because they are going to disclose it anyways. And we are saying that we think that if it will take me 14 days or right about that time to get the information, and because of deferred access principles, you're asking me to wait for up to for deferred access of up to 90 days. That's a little bit of a problem. We asked that they reduce that to 30.
Okay, was that
so that? No, it wasn't.
Okay, which is the second one?
The other one also is about clarifying transitional provision. This commencement clause was a new introduction. It was proposed.
Which is the 1 year?
The fact that it starts from next year was a new introduction.
Yeah.
Prior to that, the Honorable MP for Suhum had proposed that that it be started 1 year after accenting. But of course, when it was changed, it says that a new financial year. We thought that in a country where we have a penchant for sitting aloof
and doing nothing,
waiting until deadlines before we come and say that, oh, okay, we are now sorry, we're busy with other things, there should have been some clarity on what needs to be done between when His Excellency the President signs to the act and when it becomes operational, so that some of the basic things can be put in place.
So and that's a question coming to Chairman. Yes. So this 1 year grace period, I thought the law specifies what should happen within that period. The law doesn't.
It doesn't. It says that
one year period from which period? From which
commencement?
Commencement.
So, commencement says that it says the law comes into force from the next financial year, which means that if the president signs it tomorrow, we don't have an RTI law which will be functional until January 1 next year.
Next year.
Yes. And so all of the things, setting up the commission, appointment, government is not enjoined by law to do it.
Between now and next year, January.
They're not enjoined by law to do it.
And you see, it makes sense in the sense that you realize that there was no costs implication to the Right to Information Bill when SIM was presented to Parliament. So as at the time the bill was referred to us, even as at the time the bill was even passed into your law, we don't even know how much it's going to cost the state to implement.
I think now we have a fair idea because of your research.
That was just an aspect of it. How much is going to cost the state for the implementation of the law. Now, you are saying after the passage of the law and after the president has assented to the law, we must begin to stagger the implementation of it. And the implementation of the law has some financial implications. And now the point is that we know that in the 2019 budget, the cost of the implementation of the Right to Information Law was not factored into the budget. So if you are saying that, for instance, after the president has assented, we should begin to implement, which of the provisions can we implement without incurring an expense? For instance, establishment of the Right to Information Commission. How can we establish that without incurring an expense? How do we do recruitment without incurring an expense? How do we set up offices within the various public institutions without incurring an expense? So you realize that every step that has to be taken in relation to the implementation of the Right to Information Bill will involve some financial implications. That is why at the end of the day, we decided that let's pass the law. Let the president assent to it. Let's wait till the budget of the 2020,
which might come in November of this year,
by which time all the fiscal impacts analysis would have been done by the executive, and the executive would have known how much cost is going to go into the implementation.
And that goes into the budget.
And then that will be factored into
the budget.
And
then in January,
so that in the next succeeding financial year, the operation of the law would then be kickstarted.
So what? Now I get clarity. So what you're saying is that if the president signs this on Friday, assuming, between Friday and next year, January, nothing happens.
Right.
Wow. And so
because there's no more, there's no money.
I get it.
I get what
you're saying.
To push the implementation.
But
there are some of the non-money aspects that we could have.
But that's interesting because even in January, you still cannot enforce the law because the budget would have been read, next financial year just begun. The commission is still not in place.
Money has not
been released, and we don't know what happens. It takes another process. So you're probably talking about the whole of 2020.
And so then you see,
we'll still have nothing, and close to 2 years, and the law wouldn't have been actualized. That is scary.
You see, let's take for instance the Office of the Special Prosecutor.
Yeah.
It's not in place. Okay, but we passed the law before the implementation started.
But having to your condemn what happened to even the man himself had complained.
And money was made provision. Enough money has been made.
Finally.
Enough money has been made available to the Office of the Special Prosecutor.
And my point to that is that I thought we'd have learned some lessons from that and then use that as an example to fix this particular problem. Because here we are, we're definitely going to come back to this table and say what is happening to the implementation of the RTI. That, for me, that's the biggest concern for me going forward.
That was what we're seeking for Parliament to help us tidy up. Because if you leave it to the executive, business as usual. Unfortunately...
And that leads me to my fundamental question.
Because you see, this commencement clause thing was not part of the original draft.
So originally, we were going to implement the day the president signed.
Precisely. That was what the committee had worked with all the while. Then there was Honorable Oparensa, who actually proposed that, his proposal was quite interesting. He says that the law should come into force a year after the president's signing, except for certain aspects of the law should come into force a year after signing. So he gave the aspects relating to applying for information. So he says that everything else, setting up the structures and all of that, should take place within 1 year, but to apply should wait for after 1 year, by which time we'll have all of the structures. That was shut down because government says that, well, I mean, there is no budgetary allocation to set up the structures. But as we have it now, January, it could take us up to June, October.
The point
election year, 2020.
We must have confidence and trust in our governance structures.
History doesn't give us a confidence.
We must have
our
the
history
of the
has
special prosecutor is in place.
Yeah. But our history from there tells us that this is going to struggle.
Is in place.
I agree.
And you see,
even Matamidu himself complains, and I guess that's where the citizens' concern is coming
complaining
from.
now? He's not complaining
because eventually. But look at how long it took.
Eventually, it's been given.
As we wrap up, this is my fundamental question, Ben Abdallah. Help me here. And you in Parliament, so you know this better than most. There are many, many laws like this, very important laws. That we've clamored for, we've demonstrated, we have petitioned, we protested, eventually get passed, none as long as this, true. And then it's not implemented because the agencies that are responsible, nothing is happening. I can cite a million examples. If you ask our disabled friends, they'll tell you the Disability Act. The council, where is it? Meanwhile, there was in that clause, that law was a fascinating one. There was a 10-year moratorium, right? We are talking about 1 year and we are still complaining. There was 10 years. 10 years came, and the reason why I placed a moratorium had not been done. And my question to you, Chairman, is what is in this law that makes it impossible for us to repeat that?
The Right to Information Commission has an oversight responsibility over all the public institutions. First of all, it must promote, it must monitor, it must protect, it must enforce the right to information law. So at the end of the day, if we have this structure in place, that is why it is being given the necessary autonomy and independence that can enable it to work and work effectively. There will not be any interference from the executive. There will not be any interference from the ministry responsible for information. And I think that
is if we resource.
And I think
properly.
that if at the end of the day, the Right to Information Commission is resourced and resourced adequately.
That's a big if.
The work, the effective work that we are expecting of it to execute. The Right to Information Commission.
Final question for you. Are you confident that once the president signs, 1 year passes, new financial year, this law will be implemented the way you anticipated it?
Rightly so.
You're confident. You?
Well, I'm not too confident. I think that for us in civil society, the only solace that we take is that this is one of the bills that already has a civil society structure that has been strengthened over the years already existing. Media coalition on RTI is not dissolving. RTI coalition is not dissolving. In fact, we think
so you're going to be policing it.
So we are policing between now and up to end of this year. We are policing from the beginning of next year. So now probably the pressure is off Parliament. The pressure is now coming back to the executive.
Do you see anything in this law as been passed that will make it impossible for examples that I've just cited to happen to it?
Well, we do not see that, but I mean, like I said, we had some recommendations, and on that particular bit of recommendations, having explained to you why we made those
30 seconds.
recommendations. Yes, why we made those recommendations and they haven't been taken. That is why, and I think if I don't do this, my coalition members will hold me. Yesterday, the Honorable Chairman indicated on the floor that he had agreed in principle with us that our things should go without the changes. We never said that to him, and we, in fact, in our statement, we had indicated that the Honorable Chairman should get the records to expound that.
I thought we were even going to raise it right from the onset, which is that just at the 11th hour.
No, just
when I had finished speaking, then
you brought it in, yeah.
And then
but that's not what it is. That's not what it is. You didn't. You agree with it?
I
cannot speak to it now because then I have to take my time and explain.
Okay.
I have to take my time.
To suffice to say that you disagree with his position on.
Rightly so, I disagree.
Okay, thank you. That's the chairman of the Constitutional, Legal and Parliamentary Affairs Committee, and Samuel Obeng, Executive Director, Parliamentary Network Africa. This is a serious conversation. However, let's wait for the president to sign, and let's just keep watch and monitor so that this law, after 20 years, doesn't become a paper tiger. Stay with us. Tomorrow, there's going to be a business edition, and Monday we'll come over again with PM Express. Myself and my team will come with another exciting conversation. Enjoy the rest of your evening.